Judge, today's time day for sentencing in this matter. Let's see, I met with Zach a couple days ago. We went over the pre-sentence report. There, as far as I know, no additions or corrections to be made. I would just ask that the court have some considerations as the fines and costs, because my client is indigent.
All right. Are these the only things he's locked up on, or?
I have circuit court to deal with, but they're giving me a year with 8 months credit, I believe, if I'm correct, with Judge Patrick Collins Jr. And I just have
He's got to also complete the Dawn Farm program.
Yes, that's perfect.
Which he hasn't started yet, so it's going to be a little bit.
And Teresa Blair on behalf of probation, Your Honor, it's my understanding from the circuit court appeal that is correct, that they are recommending, he has a violation of probation hearing, I believe that's on June 12th, that they are recommending the year. However, he does have a large credit. Mr. Burlett did ask in this case, I mean, this is a year-long case, he wouldn't have that much time. He is asking for probation and to do treatment, that therefore the recommendation is provided from probation as such.
All right.
I also have a ticket to deal with on the 5th, I believe, as well, but that
On Wednesday? Before me?
I think so. On June 5th, I think it is.
What's the ticket for?
Give false information to a police officer.
I don't think our PD represents you on that.
And that is correct, Your Honor.
Yeah.
Okay.
Because, okay, who represents you on your circuit court matters?
Judge Feaster.
Torcio Feaster.
He's in good hands. He's in good hands. Wait, don't lie. You're in good hands with Torcio.
Yeah, no, you are.
The judge will attest to that.
We've just been seeing you all over the news lately, so it's an honor to be here today.
I got that video's gone viral. I mean,
And
it's just,
CMC as well last night. Oh boy. I promise not to take your signature to eBay.
That's the first time I heard. Yeah, I haven't heard that one before, but okay. Mental note, don't sign anything. All right. Okay, sir.
Sorry.
No, you're good. Anything you want to tell the court before I oppose that?
Yes. I mean, due to consideration, I pled no contest. I just truly believe that, when I was with home and new vision, I made quite a bit of progress in my recovery for the first time ever. And I see where I made my mistakes, my recovery, what I shouldn't have done. And my sponsor, he wanted me to come down to Tennessee and be with him, but due to the consideration that I really believe I needed to continue the structure, eyes on me that, it'd be healthy for me to stay here. I do have a decent relationship in the recovery community here. And again, I did make progress, but I see where I made my mistakes at. It's no one's fault. I put myself in danger in my recovery. Get what I'm saying? So with that, I'm thankful that that my agent, she recognized, she listened to what I had to say.
Miss Valera?
And instead of
She listened to you?
Yeah.
I'm shocked. Go ahead.
Instead of just taking the easy way out, of doing the time, I felt that it was necessary to keep the structure. Bless you.
Wow. I mean, God bless you.
I felt the need that keeping that structure did help a lot, and I was hoping that you take into consideration that I would do the Dawn Farms program in jail and be released to a treatment again to home and new vision. They provided everything I need.
I think he believes that if he gets sentenced today to that, he will move up on the list and he'll get into Dawn Farms a lot quicker.
And I would, as well as hoping you could put me on the list for Dawn Farms.
So you can get, okay. All right. And, okay. And I get it, Mr. Burlett, because what you did is, I guess with everything else pending, knowing what your sentence is in circuit, you probably could have just said, just sentence me to time and then I'll just be done. And the very fact that you wanted probation says something about you and where you want to go. So let's see if we can try to get you there. Okay. On the DB second charge, place you on probation for a period of 24 months. You are to pay $655 fines and court costs, $720 probation oversight fees. I'm going to indicate as arranged by probation. I understand the request that you made, Mr. Kellewald. But I'm just going to indicate that's to be arranged by probation. Ms. Clara, I don't have any issue with coming to the court. And once he's out, as he maintains his sobriety, lessening it over time. So you can earn your way out of those monies. How about that?
Yes, sir.
All right.
Also with Home and Vision, when they provide the counseling stuff, they also provide drug testing. I already told her I will sign everything off so that way she will get information with no problems.
I have no problem. I have no doubt that you're going to cooperate with us. Because you know what happens if you don't cooperate with me, right?
See you back and hopefully not on Fox News with you.
Man. No, it's okay. No, I deserved that. I deserved it.
Anyways.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. Complete residential substance abuse treatment, including all aftercare recommendations with status reports to probation. You're to complete a mental health assessment, follow all treatment recommendations, including medication protocol. There's to be no contact with Jessica Rohan or Jennifer Johnson directly or indirectly. No going to the residence or employment of those individuals. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to report to probation as requested by probation, including any home visits. You're to comply with all circuit court orders. So the review hearing, that's to be held September 9th, 2024 at 1 p.m. I'll order 365 days in jail, credit 49 served. You remain in custody until direct release to residential treatment, and then the balance is suspended. I'll do it on the other two then, I think. So that's on that kind. On count two, $50 statutory fees, 93 days in jail, credit 49 days served, defendant to serve the balance, defendant as part of that sentence to defendant to complete in jail Dawn Farm program. On count three, the malicious destruction of building less than $250 statutory fee, 93 days in jail, credit 49, defendant to serve the balance, and also on that count, defendant to serve the in jail or to complete the in jail Dawn Farm program.
Judge, just a couple points of clarification. It sounds to me on count 1, on 2, and 3 that if he completes probation or is doing well, the probation department has discretion for fines and costs.
What I'm indicating is that, and how I've done it sometimes with certain people, and this seems like a good candidate, that as he continues his sobriety, we will be looking at waiving some of those fines and court costs so that that doesn't become clearly an impediment for him.
Okay, and the last question is on number 15. Okay, he's got to serve 49 days, credit 49 days. It says to be released to treatment, but on counts 2 and 3, you want him to complete I assume that's correct, the jail sentence, so he can do the in-dawn jail program.
I want him to do the in jail Dawn Farm program.
The class.
Prior to the
Right,
release.
and then he can still be released. We can work all of that out, but he wanted to get up on the list to be able to do that.
Do
Right.
the class, and then once the class is complete,
There's-
then afterwards I would be released.
Correct.
Okay, tell me that later, then I'll write it down. Thanks, Judge. I appreciate it.
No, he
No.
understood what we were doing.
I understood it.
It's okay, Mr. Kellogg. That's what happens when you show up late.
Okay.
It's hard.
You have a nice day.
Thank you. 14A stands in recess.
A tense courtroom sentencing hearing begins as the judge calls the case, setting the stage for a decision that could significantly impact the defendant's future. What initially appears to be a routine sentencing quickly evolves into a deeper examination of accountability, addiction, and the possibility of rehabilitation. The defense attorney opens by confirming that there are no corrections to the pre-sentence report, but immediately raises a key concern: the defendant's financial situation. He emphasizes that his client is indigent and asks the court to consider reducing fines and costs, but the case is far from simple. The court soon learns that this is not the defendant's only legal issue. He's already facing a separate circuit court matter where a sentence of approximately 1 year in jail is expected, although he has accumulated some credit for time already served. On top of that, there is yet another pending charge involving providing false information to a police officer, adding further complexity to his legal situation. Despite this, the focus of this hearing shifts towards something more critical. What should be done with him now? Probation authorities explain that while there has been a violation, the recommendation in this particular case is somewhat different. Instead of simply imposing jail time, there is a proposal for probation combined with treatment, suggesting that rehabilitation may be a more appropriate path. As the courtroom absorbs this, a brief moment of levity breaks the tension. The defendant references the judge's recent viral attention, joking about it being an honor to appear before him. The judge responds with humor but quickly regains control of the courtroom, ensuring the focus remains on the seriousness of the situation. Then comes the most important moment. The defendant speaks. In a candid and emotional statement, he pleads no contest but takes responsibility for his actions. He openly discusses his struggles with addiction, explaining that during a previous period of structured support, he made real progress in his recovery, something he describes as a first in his life. However, he admits that he made mistakes. He acknowledges that his relapse and poor decisions were not anyone else's fault, but his own. This moment of accountability stands out, as he does not attempt to shift blame or minimize his actions. Instead, he emphasizes how important structure and supervision are for his recovery. He tells the court that he had an opportunity to leave the area and continue recovery elsewhere, but chose to stay because he believed maintaining structure and being held accountable was better for him. His request is clear. He asks the court for a chance to enter a treatment program, specifically referencing the Dawn Farm program, and expresses hope that being sentenced in a certain way might help him access that program faster. The defense supports this request, reinforcing that the defendant is actively seeking help rather than avoiding responsibility. The judge listens carefully. Then, in a pivotal moment, the judge acknowledges something critical. The defendant had an easier option. Given his other pending sentence, he could have simply accepted jail time and moved on. But instead, he is asking for probation and treatment, which signals a desire to change. That decision, the judge notes, says something about him. With that, the court delivers its ruling. The defendant is placed on 24 months of probation, along with fines and court costs totaling several $100s. However, the judge makes an important adjustment. Instead of enforcing immediate payment, the financial obligations will be managed through probation, allowing flexibility based on the defendant's progress. But the conditions are strict. The judge lays out a comprehensive list of requirements. No use of alcohol, drugs, or illegal substances, mandatory random drug testing, completion of a domestic violence program, enrollment in residential substance abuse treatment, including all aftercare, a full mental health evaluation with required compliance, no contact orders with specific individuals, a complete prohibition on weapons or firearms, regular reporting to probation, including possible home visits. The message is clear. This is not leniency without responsibility. It is a structured second chance. Then comes the sentencing structure itself. The judge orders 365 days in jail, with credit for time already served. However, the sentence includes a critical condition. The defendant will remain in custody only until he can be directly transferred into a residential treatment program. The remaining jail time is effectively suspended, contingent on compliance. Additional counts carry shorter jail sentences, also tied to the requirement that the defendant complete the in-jail Dawn Farm program, reinforcing the court's emphasis on rehabilitation over punishment. The defense seeks clarification. particularly regarding fines and how the jail time aligns with treatment. The judge responds by outlining a flexible approach. If the defendant demonstrates consistent sobriety and progress, the court may consider reducing or even waiving certain fines and costs over time. This creates a clear incentive structure. Success in recovery will not only keep him out of jail, but may also reduce the financial burden that could otherwise hinder his progress. By the end of the hearing, the courtroom has shifted from uncertainty to a carefully structured plan for rehabilitation. The judge schedules a review hearing, ensuring that the defendant's progress will be closely monitored. The message is unmistakable. This is a second chance, but one that comes with strict expectations and serious consequences for failure. As the session concludes, there is a sense that the court has chosen a path that balances justice with opportunity. Instead of simply punishing past actions, the judge has created a framework that allows the defendant to rebuild his life, but only if he proves, through action, that he is willing to change. And in that moment, the case becomes more than just a sentencing. It becomes a test, not of guilt, but of whether redemption is truly possible when given the chance.